Hello, and we're looking at the Occupiers Liability Act 1957 in relation to the duty of care owed by occupiers to children. So we already set out in my previous video that when you're looking to make a claim in negligence, you need to establish a duty of care. Sometimes this doesn't come through precedents or the Capara threefold test. We rely on other types of liabilities such as occupiers liability. And what the occupiers liability dictates that occupiers have a duty to ensure that lawful visitors will be reasonably safe on their premises, and we go over how to establish the various elements of the duty. Now, where children are concerned, Section 2(3)(a) explicitly states that the occupier has to be prepared that children are less careful than adults, and thus a special mention and a section is dedicated to the duty of care to children. Now, this is interesting because before we had the 1984 Act, which dealt with trespassers, essentially trespassers were dealt with very harshly. So what courts used to do is they used to find a way of making the children from trespassers to lawful visitors so as to impose a duty of care on the occupier. This is before the Act, and they did this using the concept of allurement. So in Glasgow Corporation and Taylor 1922, so harm was caused by poisonous berries that were eaten by a child in a park of some sort, and no warning of danger was given. And what the court said is, yes, this child is a trespasser, but a duty of care is owed to the child simply because children are allured to things, and this concept of allurement made the child into a visitor and i.e. gave rise to a duty. Similarly, in Jolly and Sutton LBC 2000, the boat was deemed to be a trap or an allurement to the children. So again, that would give rise to a duty, i.e. making a situation of trespass into a common duty of care. But when children are very, very young, occupiers are entitled to assume their safety lies with their parents. This is explicitly made clear in Phipps and Rochester Corporation 1955, that the defendants could not have anticipated that it was a place in which the children of age of 5 would be sent out to play by themselves. The adults, the parents, should have responsibility for that. Any parent who looked could have seen the trench and taken steps to prevent his child from going there. Defendant was entitled to assume the parents would behave in a prudent manner. So thus it depends on the child you're talking about, because when they're very young, then you can assume their safety lies with the parents. But when they're in the, kind of before adulthood, after this very young age stage, then special due care has to be given to children, especially when allurement is found on the property. So in Bourne Leisure and Marsden 2009, a 2-year-old drowned in a pond in a park, and there was a fence, but it wasn't high enough to stop the kid from falling into the pond. And actually they said that, this danger was obvious to the adults, and they rightfully assumed that any parent with the 2-year-old child would be keeping an eye and not letting the child go near the fence. So although a duty of care was owed to the child because it was a lawful visitor in this sense, there was no breach because this lied with the parents. So when the child is very young, there are ways by giving the parents responsibility that the defendants can get out of a duty situation. Thank you for watching.